At Georgetown, we're used to dealing with tough and controversial issues. For many reasons, this symposium is especially close to home. As many of you may recall, last spring, one of our third-year students, Sandra Fluck, testified before a group of members of Congress on these precise issues. As President DeGioia wrote at the time, she was respectful, sincere, and spoke with conviction. She provided a model of civil discourse. But some of those who disagreed with her position, including Rush Limbaugh and other commentators, responded with the basest sort of name-calling and vilification. Here at Georgetown, that was a moment to reaffirm our commitment to train public-spirited lawyers, no matter which side of the issue they were on, to engage intelligently and meaningfully with the world, to contribute to the profession and to public life, and to work for justice. The moment also demonstrated the role that academic institutions such as this one can play in creating a space to gather diverse perspectives to engage in open, respectful, thoughtful, rigorous examination of the controversial issues of our day. This event today is a continuation of that conversation, and I'm enormously proud that the Law Center is the space in which it's occurring. We realize that this topic includes areas of deep disagreement within the culture, across traditions, within traditions, and among members of the university community as well. It is precisely in the midst of such disagreement that we can demonstrate the spirit and strength of our community. Jeremy Waldron captured this dynamic beautifully. He wrote, "Even if people are exposed in argument to ideas over which they are bound to disagree, it does not follow that such exposure is pointless or oppressive. For one thing, it is important for people to be acquainted with the views that others hold. Even more important, however, is the possibility that my own view may be improved in its subtlety and depth by exposure to a religion or a metaphysics that I am initially inclined to reject." So thank you to each of you for coming together in this spirit of dialogue. And special thanks to our panelists who span the full range of legal, theological, and health expertise, and who undoubtedly will help each of us to think about these issues with greater subtlety and depth. Thank you all, and good day.
Thank you, Dean Traynor, very much for that wonderful introduction to our day. We're hoping that this conference will be a bit unlike other gatherings that have been convened in recent months on this issue in Congress and across the nation, in that we hope for more of a conversation and a dialogue among people of very different views and different perspectives and coming from very different traditions and academic disciplines. We're going to try to do this as much as possible in a somewhat conversational manner. I will tee up questions for our panelists. They will talk a little bit about various issues. And we expect that the three panels, there'll be a lot of cross-cutting issues, that there will be some fluidity between them. The topics that we discuss in this first panel will be elaborated upon in the second and third panels. Roughly speaking, that is in the first panel, we will talk a little bit about the legal context in which this issue is developing, and in which it has what has created this controversy, and talk somewhat about the legal questions at issue in the now 30 cases that are pending in federal court challenging the HHS rule. And the two most important questions in that litigation are whether there is a substantial burden that the federal government has placed upon religious employers, and if so, what the nature of that burden is. And if there is a substantial burden, whether the government has interests that are sufficient to outweigh that burden so as to permit it to deny religious exemptions to a rule that's generally applicable to employers throughout the land. And then more of a policy question, which is, regardless of what the law requires, what ought the federal government and similarly situated state governments, what should they do in terms of applying generally applicable laws to employers who might have religious objections and who don't necessarily want to either engage in employment practices or in services practices in conformity with the norms that the state has prescribed. Now, I am old-fashioned and have no idea how to use PowerPoint, so you're just going to have this beautiful photograph up here, I guess, or I can close it. But I did put together a little handout that I hope most of you got. And I am going to play the role here in the first 10 or 15 minutes of trying to set the legal stage so that we're sort of using the same terminology. My fellow panelists are not bound to that. They can disagree with any of what I say. And because, as is typical in situations like this, the federal government is not represented on our panels. DOJ's traditional posture is that their briefs and their arguments speak for themselves. They don't try to win their cases in fora like this. I will try, as well as being a moderator, to try to articulate the views that DOJ has been putting forward on behalf of HHS, the Department of Labor, and the Department of the Treasury, so that we understand the context. And then we'll have various speakers who have been involved in the cases and in the public debate comment upon it. So do most of you have this little handout? Hope so. If you don't, there should be some in back, and you can read with your neighbor. This is a case that comes out of the famous Affordable Care Act, the health care law that was so famously adjudicated before the US Supreme Court this past term. The court ruled on the question of whether the so-called individual mandate, turns out to be an individual choice of a tax or a mandate, was within Congress's Article I powers. This is a different sort of legal question. Here we're assuming that as a general matter, Congress can make a rule for employers throughout the land with respect to the health care insurance that is provided to their employees. And so there's two primary provisions of the act, of the law, that are relevant here, and they're on the first page. So the basic one is a requirement of employers, that most employers of approximately, it's a complicated formula, but about 50 employees or more, are required to offer to their employees participation in a health insurance plan of a certain sort. Employers no longer have the choice to not provide that to their employees. Well, they do have some choice because they can pay a penalty if they don't, or pay a fee to the federal government. We might call it a tax these days. So employers have a choice. They can either provide a health care plan to their employees or pay a sum of money to the federal government, and then their employees will get health insurance on the federal exchange. No one will go without insurance, but they won't get it from an employer-sponsored plan. That's the basic rule, and that's in the first paragraph that you see here. The second rule is a rule with respect to the health care plans themselves. And what it says is that the health care plans are required to include within the services that they give to employees, that they cover under insurance, preventive care. And this is one of the hallmarks of the Affordable Care Act. That Congress decided and that the President urged that insurance nationwide not simply be after the fact, after we get sick or ill, but that it was both efficient and humane that we focus more on preventive care. And therefore, Congress required that the health insurance plans that most of us have through our employers cover, and through Medicaid and Medicare, cover preventive care as well. And certain categories of preventive care were specified in particular, including, for instance, immunizations, preventive care and screening for infants, children, and adolescents based upon guidelines in a subcomponent of HHS, and as relevant here, additional preventive care and screenings for women that HRSA would prescribe. Because Congress found in particular that women had more need of preventive care, particularly women of childbearing years, and that they were bearing costs for that sort of preventive care on their own, costs that men, comparable men in the workplace, were not having to bear. And that women had a particular need for preventive health care coverage without having to give a copay. Now, the employees may have to contribute to the premiums, of course, but without a copay at the time of contraception. Then HRSA was tasked with figuring out, well, what is that preventive care for women that we should cover? And they asked the Institute of Medicine to do a study to determine what would be appropriate preventive care that every woman in America should have access to without huge costs. And the Institute of Medicine did the study and came up with a bunch of different categories of women's care. including domestic violence screening, breastfeeding support, and, most controversially, contraceptive methods that are approved by the Food and Drug Administration, the FDA. And HRSA, that is to say HHS and Labor and Treasury, adopted the Institute of Medicine's recommendations wholesale. They said this is what should be covered in every plan that's provided to employees, whether it's provided because you're required to do so, or even if you're not required to do so, if you're a small employer, for instance. If you do provide a plan, the plans themselves are required to cover these forms of contraception, which include diaphragms, the pill, emergency contraceptives such as Plan B and Ella, and intrauterine devices, IUDs. Vasectomies and condoms are not covered. There's no explanation in the rule for why not, except that perhaps it reflects the fact that Congress tasked HHS with coming up with women's preventive care needs. But condoms and vasectomies are not automatically covered. They might be covered in a particular plan, but the federal government has not required it. So HHS realized that requiring employers and requiring health care plans to be made available to employees to cover contraception would be controversial and would potentially pinch or in some way affect the religious liberty and the religious relationship between certain forms of religious employers, religious organizations, and their employees. And so HHS crafted what is known in the legal literature as a religious accommodation, a permissive accommodation. Now, these are found throughout federal, state, and local law. Many laws have within them legislative or administrative exceptions for certain religious claimants. It appears in all forms of laws, and they take on 1,000 different hues. You can craft your religious exemption in many different ways, and legislatures and administrative agencies do so. There are two main categories I want to set up that appear throughout the law. The first is conscience-based exemptions, right? You can imagine an exemption like the one to the draft law, the selective service law, the compulsory draft, where we say to an individual, if you have a particular religious philosophy or objection to serving with us, we will grant you an exemption, right? It's individual and it's based on conscience. It's an exemption or an accommodation meant to accommodate claims of conscience. The other category are institutional religious accommodations. And these appear all the time too. Instead of asking you, do you have a religious objection to something, a legislature or an agency will define certain sorts of religious organizations or institutions and say they are exempt from this law. Usually not based on a conscience rationale, but on a non-interference rationale. So Title VII of the Civil Rights Act of '64 is a good example. Many religious organizations defined by the statute are exempt there's a general prohibition in the Civil Rights Act that employers can't discriminate among employees on the basis of the employee's religion. And there's an exemption to that. Religious organizations can prefer co-religionists in their hiring. And that's a well-established exemption, and it's meant to preserve the right of the organization to create an employee base or a workplace that is also representative of its religious mission and that is part of its religious mission, so therefore they can hire from within. They can't discriminate against a disfavored religion, but they can prefer their own co-religionists. That's an institutional exemption. HHS here chose the institutional exemption route, right? They did, and their explanation was not that they were trying to accommodate conscience, although that's mostly the way the public debate has proceeded, and it's what we'll be discussing a lot of today. They didn't just say any employer who has a religious objection to contraception or to any other form of health care is hereby exempt. Instead, their explanation was that certain religious organizations do tend to hire from within and have as their goal not only the provision of goods and services that any other employer might have or a comparable employer might have, but also the advancement of an organizational religious aim, and their relationship with their employees is different from the ordinary employer's relationship with its employees. And in particular, Congress thought there's a legitimate reason for those sorts of organizations to insist that their employees act in a certain way that we don't usually allow employers to demand of their employees, that they act in conformity with religious tenets and beliefs of the religion of which they are all a part. And Congress further thought that the employees in such organizations would much less frequently want to deviate from their employer's requirements, and therefore would much less frequently want the forms of contraception or use the forms of contraception at issue here. And so the burden on employees would be less, and the government would be alleviating a burden on employers. So there's a lot of different ways to craft this accommodation, and the way HHS did so is on page 3 here, or the third full page. HHS, in a final rule, said that if you are a religious organization that satisfies 4 criteria, you are exempt from the requirement that your health plan, your health care plan for employees, cover contraception. Now, 2 of those criteria, I think, are fairly, well, I won't say they're unobjectionable. They closely reflect the rationale that I just described. The 4th criterion is that they have a particular tax status under the Internal Revenue Code, that is to say they're a nonprofit organization. And the 2nd criterion is that they primarily employ persons who share the religious tenets of the organization. Those 2 criteria, they're not uncontroversial, but they fairly roughly reflect the concern that Congress and the HHS described as the reason they wanted to grant a religious accommodation. But HHS added 2 other criteria also that have engendered more controversy. The first one, which is that the inculcation of religious values is the purpose of the organization, not just a purpose, but the purpose of the organization. And most controversially of all, that the organization serves primarily persons who share the religious tenets of the organization. And what this did was effective. In practice, roughly speaking, there are exceptions. It meant that churches and their auxiliaries were exempt, but that social service organizations, employers, Catholic charities, and universities that are affiliated with churches and that do good works as part of their religious mission are not exempt because they're serving the public rather than just the flock. And even if they only hire from within, they would be ineligible for the exemption because they don't only serve people within the church. This was met, as most of you know, with some degree of controversy. And I think this took some people, probably HHS, by surprise, because these 4 criteria, HHS didn't pull them out of a hat or out of thin air. They adapted them from the exact same laws that have been in place for many years in the 2 largest states of the nation, New York and California. And both of those laws in New York and California were challenged on constitutional grounds, very similar to the arguments we'll be having here today. And the highest courts of those states rejected the legal challenges to those. And so I don't know that HHS has said this out loud, but I think they adopted these 4 criteria because they had been tested in the courts. They had survived scrutiny. They seemed to be safe. Turned out they were anything but safe from at least public controversy. Many organizations, for-profit employers, nonprofit employers, and social service agencies, archdioceses and churches themselves, and schools thought we should get an exemption too. You're being too narrow in the religious organizations and employers that you're exempting. We have the same conscience claims that the exempted organizations have, but you're not granting us the exemption. Now, one response to that is we didn't grant this to alleviate conscience problems. We granted it for institutional autonomy and the like. But HHS and the Obama administration, as most of you know, decided, yes, you're right, we should expand our exemption somewhat. We should do more. We should think about a second religious accommodation. And so they did 2 things, which is on the next page. The first thing they did was create a safe harbor that said effectively that until August 1st of next year, 2013, if you are a religious organization, a nonprofit religious organization that satisfies 4 other criteria that I have listed here, that we can talk about later, don't worry about it. You can continue not to provide contraception in your plan until August 1st of 2013, and we won't penalize you for doing so. And during that period, we are going to try to come up with yet a second, what I call here the prospective, religious accommodation that would go beyond the first one. And HHS gave a few examples of the way it might accommodate these other nonprofit religious employers. In particular, the ones that have gotten the most attention are, they said, for one thing, if your thought is that somehow you claim that you are cooperating with evil, what you perceive as evil, when you provide a health insurance plan, when you pay a copay for the premiums that go to cover birth control in some circumstances. Well, fine, we won't make you do the payment. We'll have the insurer, the insurance, the health care plan itself pay for the contraceptive care, so you are not implicated in it as much. Of course, this isn't final yet, so we don't know how they're going to do that, how they're going to make that law, or what the statutory authority would be for them to require the insurers to cover this at their expense. Now, one of the theories here, actually, one of the theories that HHS has adopted is that actually there is no additional expense to covering birth control. In fact, covering birth control in the plan means you save money, not spend more money. And the Institute of Medicine found this, and other groups have found this, and HHS has argued, and DOJ has argued this in court, that in fact there is no expenditure of money because preventing unwanted pregnancies actually saves you money in healthcare costs that are associated with unwanted pregnancies, which are much higher than the costs of birth control. And so to the extent there is money, though, it wouldn't be paid by the employer even as part of premiums. Instead, it would be paid by the insurance companies. Then there's this issue of, well, okay, well, what about an organization that self-insures? I believe our law school does. I'm not sure about that. But many organizations, I don't know about many, some organizations self-insure. They provide the insurance themselves, so they're the insurer, so that doesn't get around that problem. HHS suggested, well, maybe there would be a plan administrator, a third-party plan administrator that we could make available who would pay for the costs of health care. All of that is still unknown, how that will pan out. Okay, so as I said, there have been, I believe, 30 lawsuits. I'm going to turn the podium over to Lori Wyndham in a second, and Lori works at the Beckett Fund for Religious Liberty, which has brought about half of the lawsuits, I think, or a third of them.
Just 5.
Just 5. It just seems like half, Lori.
But you've got them all on your website.
30 employers of various different kinds, as I said, the archdioceses, social service agencies, but also Hobby Lobby, right, and the Hercules agency. That is to say, for-profit employers who say, we're owned by a family, by a husband and wife, and we have religious tenets too that we think are implicated by this. And why would you limit this your exemptions to nonprofits? There's no reason in particular to do that. And the claim in these cases, but Lori can correct me if I'm wrong, the principal claim of the burden is, and you hear this all the time in the public debate, that this law will put the employer to an untenable choice between complying with its legal obligations and obeying religious dictates. It's forcing us to choose between disobeying the law and disobeying our religious obligations, which doesn't sound very good when put that way, right? It's something that the government should, generally speaking, try to avoid. There hasn't been a great deal of articulation of why it does that any more than other forms of payment, such as taxes or your salary dollars, that are also used for activities that a particular employer has a moral objection to. And that's one of the things we're going to be focusing on today. The lawsuits are brought under several different provisions, constitutional and statutory, and we're going to focus mostly on one here, which is the Religious Freedom Restoration Act, a statute passed in 1993, signed by President Clinton. Melissa Rogers and I and many in this room worked to, and I see Michael Lieberman, a bunch of other people here worked to get RFRA enacted, a religious freedom statute, and a follow-up statute called the Religious Land Use and Institutionalized Persons Act, or RLUIPA, because President Clinton was a great believer in religious liberty and religious exemptions. And what this statute does effectively is reinstitutes as a statutory matter a constitutional test that the Supreme Court had been applying between 1964 and 1990. And I have the text of that, which many of you know, on the last page of your handout. And it says that a federal law that substantially burdens the religious exercise of a person may not be applied to that person. You must grant the religious exemption unless not granting the exemption would be in furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling interest. It's the old Supreme Court test, now instantiated in a statute. There are also free exercise clause and establishment clause claims and Administrative Procedure Act claims that have been brought. I think they're less interesting and far less likely to gain any traction. If any of our speakers wants to speak about them, that's fine. But I think RFRA is really where the action is, and the questions of whether those two what are the answers under those two tests. So first, the burden is on the plaintiff, the employer, to demonstrate a substantial burden on their religious exercise. And only if they do so, then HHS would have to come back and say, denying them an exemption nevertheless is the least restrictive way of furthering a compelling governmental interest. And those are, roughly speaking, the two broad questions that we'll be discussing throughout the day here. What is the nature of this burden? Is it substantial? How should courts, regardless of how we in this room articulate and understand those burdens, how should courts deal with them? Should courts largely defer to employers when they claim that there's a substantial burden on their religion, even if they have doubts? There's some Supreme Court case law suggesting that it's no business of the courts to second guess what religious claimants think their moral beliefs are, or claim their moral beliefs to be, or their burdens are. And so I think with that, if everyone, I hope that sort of sets the stage for what we'll call the first religious exemption, or the existing one and the prospective one, the safe harbor and RFRA. And with that, I'll ask Lori first, and I will introduce the panelists as I first address them. Lori is the senior counsel at the Becket Fund for Religious Liberty. She's represented a variety of different religious groups and individuals, I believe, at the trial and appellate levels in a lot of litigation. The Becket Fund is a wonderful organization that does a lot of very interesting religious liberty work across a lot of different perspectives and a lot of different issues. And they're running a wonderful website that collects a lot of the documents in these 30 cases, including the ones that they have not brought. And I should add here that we, the Berkley Center at Georgetown, which is co-sponsoring this conference, we are putting together a webpage of our own with links to many of the most important documents, both the administrative documents, writings by the people that you will hear from today, court cases and decisions and the like that will be up early next week, if not before. So you can all, and we'll continually update it. Anyway, the Becket Fund site in the meantime is a great resource and will continue to be one. And Lori has litigated on free exercise establishment clause in RFRA and RLUIPA cases. And so, Lori, can you give us an overview of where and you can podium or seat, whatever you feel comfortable with. Give us an overview of where the litigation is now. I know one case, there's been a ruling on the merits in one case at a preliminary injunction stage, and there's 29 other cases that haven't reached the merits yet, right?
Yes, that's right. And so we've got one case out there. It was for a for-profit company, the Hercules case out of Colorado. For-profit companies are not subject to the safe harbor, and so courts are going to have to look at those cases and make decisions on those cases now. This was the only court case so far to actually get to the merits of does this violate RFRA, and the court in that case said likely it does, granted the preliminary injunction. The remaining 29 cases are still in the very early stages. Most of them are still at the motion to dismiss stage. 3 of those have been dismissed on standing and ripeness grounds. These were not merits decisions, but they were decisions based upon whether the organizations could come in and sue while the second rulemaking is still pending and while the safe harbor is in effect. So the Nebraska case and then 2 cases in the D.C. District Court were dismissed. 2 of those, Wheaton and Belmont Abbey, my own cases, are currently on appeal before the D.C. Circuit on standing and ripeness. We're expecting a decision on those before the end of the year. All that to say that this is still very preliminary. We have only one court case so far to actually look at the merits of these questions, and the rest are still working their way through the system and are going to be for the next few months.
So one thing that's interesting, so the case that was not decided on the merits, but at the preliminary injunction stage, was by Judge John Kane in the District of Colorado. And as Lori mentioned, the oddity of this case is that the cases that are getting to the merits first are the ones in which the plaintiffs are in some respects the least sympathetic, the for-profit employer cases. So that case is it a Becket case, Hercules? No.
No, it's not. It's ADF case.
An ADF case. The Hercules Industries is a Colorado S-Corp engaged in manufacture and distribution of heating, ventilation, and air conditioning products and equipment owned by 4 siblings, William, Paul, and James Newland and Christine Ketterhagen, and they comprise the board of directors, and they are religious observants who are opposed morally to birth control, to the use of birth control, and they don't want their air conditioning parts company to provide a health care plan to their employees. They don't just hire from within their religion, they hire widely because they have to by law, and I don't think they have any objection to it. They claim we don't want to provide this to our employees, and they moved for a preliminary injunction. As Lori pointed out, the other cases, the 25 or so cases involving nonprofit organizations, the government's posture as to those is, it's too early. We've told you we're going to create another religious accommodation. You might be covered by it. We don't know yet. We have to wait till August 1st to find out. And in the meantime, you have a safe harbor. You can continue business as usual in the meantime, and two or three judges have ruled that the government was right on that. So the irony is that the cases that are going to the merits first are the ones involving the for-profit corporations making religious claims. And Judge Kane issues this decision on preliminary injunction, and one thing that was interesting about it, at first he discusses whether they could show a likelihood of success on the question of whether this substantially burdens their religious exercise, and there's a gap in his opinion. He says, this raises a difficult and interesting question, and then he just goes on. He doesn't say there's a likelihood of success. He sort of skips right over that. But their claim, like the claim on Beckett, the front page of Beckett, is this claim of this is forcing us to a terrible choice between two things we don't want to do. But that hasn't really been fleshed out in much of the briefing yet. Is there anything you can tell us, Lori, about the sorts of claims your clients are making on why this creates a substantial burden?
Sure, and I'm going to disagree a little bit. I think that it has been fleshed out in the briefing and in the complaints. I think that the analysis under RFRA is really a four-part analysis. Is there a religious exercise, a sincere religious exercise? Is there a substantial burden on that exercise? And then the burden shifts, as you said, to the government. Is there a compelling interest? Did they use the least restrictive means? So in this case, we have a sincere religious exercise. The Catholic Church's opposition to contraception is longstanding and well known. The opposition of many evangelical and Protestant groups to abortion-causing drugs, or what they believe to be abortion-causing drugs, even at the very early stages of pregnancy, is longstanding and well known. I don't think that there's any good argument that these beliefs are not sincere. Coupled with that, we have longstanding teachings about material cooperation and something that is wrong, about entering into contracts and paying money for someone to engage in an activity that you believe is morally prohibited, underwriting, sponsoring, and facilitating activity that you believe is morally wrong. And so these beliefs are longstanding and sincere. Then you have the question of, is there a substantial burden? The burden here is a significant government fine, $1,000 per employee per year. If you choose not to offer health insurance, that's over $500,000 for one of my clients, Colorado Christian University alone. If you try and skirt the law, and to what degree you're able to do that is debatable, if you try and skirt the law and still offer health insurance but not cover these things, then you're looking at $100 per employee per day. So in the case of Hobby Lobby, you're looking at $1.3 million a day. If that's not a substantial burden, then I'm not sure what is. The case law is clear that a fine directly assessed on religious exercise is a substantial burden. This goes back to Sherbert, where they analogize the lack of unemployment benefits as a substantial burden because they said it's like a fine that's being assessed on your religious exercise. And so I think that the burdens here, I think the religious exercise is clear. I think that the burden is clear. I think we may be disagreeing about exactly how that analysis is applied.
So I guess here I'll put on my proto-government hat a little bit. I don't think there's many folks here who would think that if what the employer were being required to do is something that they thought violated their religious tenets, then surely the nature of the fines you're discussing are enough coercion to satisfy that first part of the RFRA test. But I guess what many of us are thinking about is, why is that first predicate satisfied, right? Why is this different from, for instance, paying taxes that get used? So one of the things that you and other plaintiff groups argue in your briefs is that the government, at the fourth point of the RFRA analysis, could do this itself, right? It could pay for this. It could create a government-funded program to cover health care. If that's what you think is so important, why are you forcing employers to do it? Put your money where your mouth is. Well, that would be paid for with tax dollars, including the tax dollars from your plaintiffs, and they pay their employees salaries. You know, instead of the health care plan, it will now be the salaries that you pay them that they'll use to engage in the use of contraceptives. So why, if this violates religious tenets, why don't those other forms of payments likewise?
I think there's two responses to that, and one is legal and one is theological. I am not a theologian, so I will defer. But one response to that, getting into the theological response, is that taxes are different because you're talking about paying money to someone who then has the independent choice to go out and use it however they will. That's, I think, sweeps in both the taxes and the employee salaries. It's different when you're asking an organization to enter into a written contract. hand over money, and say, okay, we're going to contract for you to then go out and provide these services to someone else. I think that is different. That is a closer link, and I think that the law is going to recognize that. The legal issue that we're getting into here, though, I think it's important to recognize this, and you alluded to this earlier, is the Thomas argument and the Hernandez argument that courts are not arbiters of scriptural interpretation, that it is not their job to go through and take two opposing beliefs and decide who is more right about, for instance, Catholic doctrine. And in Thomas, of course, you had somebody who's Jehovah's Witness. He said, I can't in good conscience go to work and manufacture tank turrets. They had another Jehovah's Witness come in and said, oh, yeah, that's fine. That's not a problem. You can do it. And the Supreme Court said, no, it's not our job to go in and decide who is right about the teachings of the Jehovah's Witness faith. It's our job to ask whether this person is sincere, whether he has been burdened. And so I think to the degree that we're getting into these questions of, well, we think it's really okay for you to contract for these things, we don't think that's different. I think you are starting to impinge on that area and get into this inquiry that the Supreme Court has prohibited about saying whether, about deciding who has more correctly perceived the teachings of Catholic or other denominations' doctrine.
I was going to turn to Louise, but let me ask Melissa, because I know you've thought about this question some, Melissa. I know that you too are a bit skeptical of courts starting to second guess whether you agree or not with the basic theological claims being made here. You have traditionally been very wary of courts starting to second guess, even in cases here where the claim is not we know Catholic doctrine better than you do, but just you seem to be acting in other ways that are inconsistent with the claims that you're now putting forward. We don't understand, so this is raised in the DOJ brief and elsewhere. We don't understand why, if you're willing to do these other things that seem to implicate the concern that you're articulating just as much, why this one bothers you so much. Do you think the courts should largely, should we leave it to us academics and observers to debate the substantial burden question and keep that out of the courts?
Well, I think that the substantial burden question has subjective and objective elements to it. And I think I would agree with Lori about the characterization of the Thomas case, that we don't want the government coming in and saying, well, your beliefs don't make sense to us, or other believers interpret the same faith you say you have differently, so you can't make that claim. I think that that is something the court has properly said is not the role of the courts, that the courts can't do it, they'd mess it up if they tried, and they ought to stay out of it. And I do think the burden also has subjective elements to it, when a practitioner would say that this does impinge on my faith. At the same time, there are other things that the court can properly assess, things like the sincerity of the claim and the substantiality of the burden, which they can look at that are not in an objective way.
So when they're doing that, Melissa, if they're testing sincerity, or what was the other thing that you said?
Substantiality.
Substantiality. Is it proper for them to look at the person's conduct in what appear to be analogous situations and say, we believe you, you're sincere, but this didn't seem to be so troubling to you in this other situation, so we'll assume it's not substantial here?
I'm not sure about that. I mean, I think I'd be very careful about trying to say, get inside the faith and say, well, your faith didn't stop you from doing this, or what about that? I mean, if they were, there may be some relevance to that, but I think that the court can look at, for example, the burden that would be put on the believer by the state, and say, for example, if an insurance company is providing the benefit to the women working for objecting religious employers, and say, well, if the insurance company is paying for and providing this benefit, and, for example, there are intervening private choices going on by the woman to decide whether to take the company up on that offer and whether to use the contraception benefit, then they can look at things like that and say, while we're not going to question your beliefs, that doesn't look to us like a substantial burden. Let me just make one other note. Personally, I look at these cases that involve entities that would qualify for a Title VII exemption differently than I look at entities like most for-profit entities that would not qualify for a Title VII exemption. Because those, when you qualify for a Title VII exemption, as Marty said, then that entitles the religious organization to be recognized as a religious association or corporation and to discriminate on the basis of religion in employment matters, to hire and fire and discipline on the basis of religion. Now, if an organization would not qualify for that Title VII exemption, and I think while some for-profits would, not many would not, then in those cases, I feel I'm less sympathetic where there's a for-profit business that does not qualify for the Title VII exemption, because I think if they cannot make employment decisions on the basis of religion, then I don't see that they should be able to make religious calls on the types of benefits that they do offer their employees. And in a case, this case, where there is a federally mandated health benefits that are at issue.
So we are going to take that up, and I'm going to take it up with Rob in a few minutes, but I want to hold that thought and think about whether that articulation, Melissa, is that an argument that the for-profit corporation has less of a claim to a substantial burden, or that the state interest is higher on the other side because of the implications of starting to expand exemptions into the for-profit sector? So, but we will be getting into that. I neglected to introduce Melissa, I think, because I just naturally assumed that everyone in this room knows Melissa, because we've all worked with her. Many of us have worked with her for so long. But let me correct my mistake. Melissa's director of the Wake Forest Divinity School Center for Religion and Politics and Public Affairs, promoting research, study, and dialogue regarding intersection of religion and public affairs. She teaches at Wake Forest classes on Christianity and public policy and church-state relations. In 2008, she published a book, Religious Freedom in the Supreme Court. Melissa's been central to most public federal debates about religious liberty for a very long time. She served as executive director of the Pew Forum on Religion and Public Life, and is the general counsel of the Baptist Joint Committee on Religious Liberty. And she's a senior fellow at the Brookings Institution, and a lot of other things as well. But she really is one of the central figures in Washington whenever these issues come up, because she has a perspective on many different groups and individuals' views on these things, and is able to bring them to bear. Well, let me go to Louise now. Louise Melling, an old school classmate of mine.
I am old.
So we both just graduated three or 4 years ago, right? Louise has been at the American Civil Liberties Union in New York forever, since 3 or 4 years ago when we graduated, right? She's been there for quite a long time and has done wonderful work. She's now the deputy director of the ACLU and the director of its Center for Liberty. And what's interesting about that is the ACLU, this is the part of the ACLU that covers LGBT and the AIDS Project, and the Reproductive Freedom Project, which Louise used to direct, and the Women's Rights Project. But also, and traditionally this is a very fundamental and central part of the ACLU, the program on freedom of religion and belief. And so the ACLU is committed to both sides of this debate, right? Religious liberty and women's health and reproductive rights. So Louise, let's turn the conversation a little bit to get us started to the government interest side of things, although you can certainly speak to the burden side of things. In these cases, the DOJ briefs have basically articulated two government interests that coalesce, and HHS did as well in the rule. One about women's health and the other about equality in the workplace. And roughly speaking, I'm going to simplify a little bit here. It goes something like this, but tell me if you think this is a fair characterization. Congress found, and HHS found, that women have to spend a lot more money on preventive health care, in particular reproductive care, and pregnancy prevention, than men do. It's just a fact of life for a variety of reasons that come together. And women were, in fact, spending much more of their salaries on birth control and other forms of reproductive health than men were. And so the idea here was, this puts women to, if they have to pay for it themselves, if there's a copay or they have to pay out of their salary, it puts women in the workplace to a choice, and neither end of the choice is a desirable one. Some women will go without birth control and risk unintended pregnancies, which is bad for the women and has all of these health consequences that the Institute for Medicine found, including depression, and most particularly, they actually focused mostly on the health of the fetus and the health of the child once it's born, because studies show that in an unintended pregnancy, women are taking fewer precautions before that they know that they're pregnant, and therefore fetal health is worse in those situations than others. But also there's incidences of depression and other health costs during the unintended pregnancy that wouldn't necessarily exist if the woman had not gotten pregnant or had had a wanted pregnancy. But in addition, HHS rules, some women will spend the money and get the birth control. Not all of them will go without, and those women won't suffer the health consequences, but they will suffer a financial consequence, which is they are effectively being paid less than their male colleagues doing comparable work because their burden, the financial burden that's placed upon them, is greater, and we don't want that either. We want women's equality in the workplace. And so some women will choose make one choice, and some women will choose the other, but we want to avoid both. And that therefore the government has these two interrelated, conjoined, compelling interests. The hard question, I think, is why does the government need, well, there's two hard questions that have been raised in this preliminary injunction ruling. One, since the government is not requiring certain groups of employers to provide this health care, in particular the churches and the other religious exemptees, and so-called grandfathered plans, right? So temporarily, if you had a plan in place that you had not changed as of a certain date, and you don't change it going forward, you're not subject to not just the contraception rule, but the general requirements of preventive health care here. You're exempt, and that's a lot of employers. So if the government's interests are so important, why are we exempting all these groups? And secondly, if the government's interests are so important, why doesn't it pay for it itself? But I just tee up that series of questions for you and ask you what your thoughts are on them.
I feel like I'm back in law school.
I did this in law school too, right?
Miss Melling.
Exactly. So at the ACLU, we do totally respect the religious interests, and I believe that the religious interests here are very sincere, and don't believe that questioning the sincerity of those interests is for the place of the court. But we also care deeply about anti-discrimination principles, and when we weighed in, we ultimately came out in support of the narrow exemption. And we came out in support of the narrow exemption. This does go to your question and sort of in a context in significant part, because when you think about institutional exemptions as opposed to individuals, the considerations are different, and part of it was almost what's fair. So what seemed to us right about what the government did is that you have a question of, for me, the purpose of the organization, of the institution matters, because when you have a purpose that's religious and you hire people of the faith, you really have given sort of notice to your employees, and in a real sense about sort of what they're walking into, and people are kind of accepting and embracing a particular tradition.
So
whereas
Louise is referring to that first criterion on that on the first established page. And Louise, it's phrased the purpose of the organization. Would you be more comfortable if it was like a purpose or a primary purpose? Because I think part of the concern is we have many purposes, and are we not exempt if we have more than one?
I'll go with the today. How's that? I'm going to go with the, in significant part because, look, this comes down to largely being about houses of worship and other places that are very close to the center of religion. And the further out you go from here maybe to educations and hospitals, and then you go to Hercules, and then you can sort of go further out. The further out you go, the more likely you are to be imposing your religion on others and really burdening other people. And to some degree, this comes down to a basic view of once you open your doors to the public, once you participate in the public world, you play by public rules. And that's true if you were Piggy Park, the restaurant in South Carolina that had sincere religious objections to serving African Americans when the civil rights movement came in. It goes to when you're at the pharmacy in terms of whether you serve women who seek to control reproduction. And it goes to the inn when you advertise all over your website you're a tourist destination, sort of except for lesbian and gays. And as to the state interest, back to your actual question.
No.
But for the state interest, I mean, all these issues are real. The discrimination against women in terms of healthcare, the discrimination for women in terms of cost, which amounts to salary differentials, the discrimination in terms of being able to control your reproduction, and we see what Justice Kennedy has to say about that. If you can't, and what many of us believe, more important, if you can't control your reproduction, you can't control many other ways in which you participate as equals in society. And I would sort of add to that central to longstanding notions of discrimination against women were discriminations based on reproduction and women's proper roles, in some sense, and proper roles as women, and singling out contraception as a form of that. And I say that, of course, respecting that there are sincere religious objections that are to the contrary, but once you are in the public sphere, then for us, the anti-discrimination principles outweigh those harms.
And is that true even for the group that hires only from within its own co-religionists?
Well, first of all, I understand why you're interested in this question. I don't think that the lawsuits would really be different in the sense that I don't think that there are many plaintiffs who are hiring only people of their faith in this pool. And I guess, I take seriously your question, and there are other contexts where the sort of who you serve matters more, but I think it also does go back a little bit to our idea of the further out you go, the more you're opening your doors up, the more you are embracing or expected to embrace basic norms about salaries, basic norms about equality, basic norms about access, basic norms about other general public rules.
So it sounds, Louise, as if you're describing, and I think there has been at least a bit of recent litigation. There was some about 20 or 30 years ago under Title VII, and I think maybe it's reviving, or that's what you're suggesting, that your concern is not limited just to this rule, but that if for-profit employers and other employers who do not take advantage of the Title VII exemption are allowed religious exemptions to this law, what's to prevent them from going into court and saying RFRA requires us to have an exemption to all manner of employment laws, right, including the law against discrimination on the basis of sex or race or religion that's not a co-religionist preference, or, I don't know, workplace safety rules or conduct rules for employees and the like. Is that really a threat? The courts, it is true, more or less rejected those sorts of exemption arguments 20 or 30 years ago. Are you seeing them more now?
Marty's right that when we think about this context, the contraceptive context, we're also thinking about it, as I'm sure my co-panelists are as well, in the context of what's happening more broadly on these issues of religious liberty, sort of meeting anti-discrimination principles. So there are the 30 cases in the contraception field. There are a whole series of cases or instances where institutions, and in particular public accommodations, have refused to provide services or have closed their doors to lesbian and gay couples once they discover that they're lesbian and gay couples, and that goes to the bridal shop for the woman buying her dress, and it most particularly goes to inns. There's a spate of cases now. It's us bringing the lawsuits against the inns for turning people away. There's a spate of cases right now also with different Christian schools having fired women because they became pregnant while they weren't married, or because they have recently sought assisted reproductive technologies. And arguing,
those were the sorts of cases the lower courts were rejecting 20 or 30 years ago. They had seemed to disappear, those cases, but they're returning.
I think we read about sort of 7 instances. They're not all lawsuits now, but we just filed in 2 different jurisdictions on Monday related to these kinds of cases. So these questions are, and they're the pharmacy cases where the pharmacies are resisting providing, filling contraception prescriptions.
I believe there's
and we go back, and these are all different versions. I would say they're the 21st century iterations of what we saw in the 60s, be it through Piggy Park, the restaurant that wanted to preserve an all-white establishment, as well as, Bob Jones in different iterations. And, for us, one of the questions is, and, this comes up with the pharmacies, and there's a way it comes up with the insurance too, but you know, in the context of pharmacies and the inns, people will say, well, surely there's probably another pharmacy, or there's probably another inn, or who wants to stay in the bed and breakfast where people can't stand you? And those questions we didn't say around Piggy Park, well, I'm sure there was another restaurant, you know, within a reasonable distance where somebody could go, or do you really want to have dinner at the racist diner? You know, there were principles about, we understood the dignitary harm in a sense of what it means to have, be it the whites only sign or the heterosexual sign only, or not to have in your business place benefits provided unless, you know, you want to control your reproduction.
Wouldn't one answer to that be, I suspect the plaintiffs, if those cases are raised, and the ACLU has actually filed a couple of amicus briefs now in these cases, raising these sorts of claims and giving the historical perspective about how historically religious claims to religious exemption and burdens on religious liberty have been used by employers and providers and inns and restaurants throughout the years to resist race discrimination laws, sex discrimination laws, and the like. Isn't the response to that, well, at least there, if the government has a compelling interest, it's much more uniform in its enforcement of it, right? The principal claim here on the third or fourth step of the RFRA analysis is HHS is hardly being consistent enough. There's too many employers that it's not requiring this of, and if it's not requiring of the church, why should it require it of Hercules, Inc., right? They're both involved in, they both have the same religious objection. Why should these brothers and sisters who own Hercules, Inc. be treated worse than the Catholic Church, which has a lot more resources than they do?
Well, several things. One is, I mean, as Melissa was just saying, you know, Title VII and many of the statutes have different kinds of exemptions, either because of the size of your organization, or in the case of Title VII, you're a religious association or educational facility and you get an exemption for religion. But it is not as if all comers get an exemption in Title VII for discrimination based on sex, even if it's motivated by genuine religious beliefs. In the context of the HHS rule, it is ironic in some sense that when granting an exemption, you sort of face trouble because you grant an exemption trying to find a way to accommodate those who you most sincerely believe sort of need or where it's appropriate. But also as to the grandfathered provisions, I think the thinking is at some point as time passes, you know, it's sort of like the ADA, as time passes, those grandfathered insurance plans will change such that the benefits will then be extended. And it's about sort of tiering. I mean, all these questions are really about, to some degree, how you tier and face change in society.
Right. That's the argument DOJ has made in its briefs, which is that the grandfathering exception is only temporary, and it's to balance out another important state interest in, you know, not having a convulsive change for all these folks who have very complex health insurance plans already in place. When they make a change, whenever they make a change, they will then be subject to these rules, but it's sort of a built-in kind of overtime response. But then there's also this discrimination among religious objectors that is made a lot of. Let me ask.
But that's true in most every.
It is.
Statute.
So
I mean,
the irony here is that the argument here is once the government has voluntarily provided a religious accommodation to some employers, there's a constitutional or a RFRA harm in not providing it across the board to people who have the same sort of religious objection. And that, I mean, there's an obvious irony or something here, right? Which is that you're going to discourage legislatures and agencies from granting any religious exemption if the people who aren't entitled to it then go into court and say, aha, you gave it to 1,000 groups, therefore it has to be extended to all. I think the courts will be very cognizant of this concern. Let me ask, Lori, without going into all the race discrimination cases and all the cases that Louise is mentioning, let's just talk about the healthcare case. If your clients prevail on birth control, wouldn't the logic of those cases under RFRA mean that the Christian Science organization would be able to not provide healthcare at all to its employees, or the Jehovah's Witness organization would not, would be able to deny reimbursement for blood transfusions? Or just an individual, owner of a corner grocery store who has a religious objection to the entire, so-called Obamacare, right? Thinks that it's religiously prohibited for the government to be imposing this how far are you opening the door for these other sorts of broader religious claims, even within the health insurance context?
You know, that's always the first question that comes up is, well, if we do this, aren't we going to have an exemption for everyone? And I think the answer is no. I think that we've already struck the right balance with RFRA, where you have to go back and look at what is the religious belief, how is it being burdened, and then how is the government acting to justify that burden. And so in cases of Christian Scientists or Jehovah's Witnesses, depending on the case, you may have some government, you may have a compelling government interest, you may have a government regulation that can pass the test, and we may say, okay, the government has actually struck the balance correctly here. Obviously, I can't know without knowing the facts of a particular hypothetical. You know, in the case of somebody who just says, well, I object generally, again, it would depend. You may come closer then to cases like Lee or Hernandez, where you're looking at objections to an entire government scheme, which the Supreme Court has frowned upon. But RFRA, I want to reiterate, or I want to say, RFRA has been the law now for 19 years. Before that, we had the Sherbert Standard for 25 years. Exemption schemes are nothing new in federal law, and we've managed pretty well so far. So I don't think that following the law as it's written in this case is going to bring the whole house down. I would also say that with regard to this mandate in particular, you look at government estimates on the grandfathering, and it's in excess of 100 million Americans are on plans that may be exempt due to grandfathering in 2013. So I think you're really hard-pressed to say why you need to go and impose this rule for the 200 people who work for the monks at Belmont Abbey College when there's 100 million Americans, a third of the population, already on grandfathered plans next year.
Okay, so Rob Vischer has been waiting patiently. And we're going to bring Rob in. And Rob, I'm going to offer you the opportunity to respond to any of these points, but I know that you want in particular to discuss how this apparently very complex question becomes infinitely more complex when it's a for-profit employer that's at issue. Rob is a professor and associate dean for academic affairs at the University of St. Thomas School of Law, where he came from the St. John's University Law School. He wrote a really fascinating book in 2010 that I highly recommend to everyone. Amy brought it to my attention, called Conscience and the Common Good, which examines in an extremely thoughtful and interesting way many of these and related questions. And he is soon to publish a new book, I'm told, about Martin Luther King, called Love and Justice. That's a good title for a book, right? Yep. Who could be against that, right? Love and Justice, Martin Luther King's Lessons for Lawyers. So for you law students in the room, that's something to come out, and I believe that's being published in a couple of months.
Yep.
Right, and that is about ways in which, according to the book, he defines and defends the relational dimension of conscience and identifies ways in which our legal system might better maintain the communal venues in which the dictates of conscience are shaped, articulated, and lived out. Well, is the Hercules Inc. company one of those venues, Rob?
Yes, but before I answer that question, can I take you up on your invitation to respond to other comments are made? So first, my overarching comment would be, you know, these disputes are going to get a lot more complicated unless we go to a single-payer healthcare system. I mean, that takes care of a lot of what we're talking about today.
Then we won't have conferences.
Well, that's right. We'll lose the conference circuit. In response to a couple things that Louise said. One, you know, if our legal framework aims to erase dignitary harms, we're going to have a lot of work to do. I don't think the best way to interpret racial discrimination laws is as taking cognizance and doing everything we can to stamp out dignitary harms. I think it was aimed at dismantling an entire social system that was geared toward the subjugation and marginalization of African Americans. And so I'm concerned about using how we went about dismantling Jim Crow as the template for how we handle cultural disputes today. Now, I'm going to talk about just for a couple of minutes about the Obama administration's exemptions that we've been talking about, those four criteria. I'm going to talk about number 4, about nonprofit status. Before I get there, though, I think the way that Louise framed those, I think is a very common way of framing those, and it's part of the problem. So she described the first one as whether the organization has a religious purpose. That's not what it says. It's whether the purpose is the inculcation of religious values. There are many religious purposes that are not the inculcation of religious values, which is why that's so controversial. The other thing she said, where that the house of worship is at the center of the religion, and as you move out to other activities, you're moving away from the center toward the periphery. That's a deeply contested, religious assertion there, to say that, the worship is the center and the soup kitchen is closer to the periphery. I don't know that that's the case, and so that's one reason why these criteria are so controversial, because they're so deep. They make such deeply contested assertions about what religion should count. And I know there's reasons why they have these criteria, but it's not self-evident that this gets at the heart of religion in terms
Rob,
of who
what about the second one? What about the Title VII?
Oh,
Are you more comfortable with that one as a requirement?
Well, I'm more comfortable with it than the first one. I mean, it still is. I think it's perfectly possible for a religious organization to signal to the surrounding community, this is who we are. Would you like to work for us? Consistent with our mission. I don't have a problem with that. Now, you get into some issues where employers occupy such a large segment of the employment market that then you're removing people from their ability to earn a livelihood. I get that. But to me, it's not about an inalienable right of an individual to work for an employer on their own terms without being caused difficulty by the employer's mission. It's more about, does this person still have access to the basic goods and services that we deem as a political community to be essential to participation in our society? The fact that when you're talking about Walmart, I understand it gets a little dicier, but when you have, some of these groups that are bringing suit now, when you have a relatively small company in the grand scheme of things that has been above board all along about who they are and what they stand for, I'm not sure that the individual employee has or should have a trump card over the implications of the mission of that organization. And that brings me to the fourth criteria, which has been the least controversial by far. And I'm not
going to change that now.
Well, I don't know if I will, because I'm of two minds about it as well. But the notion that nonprofit groups are the only ones who should be entitled to an exemption from this, I just think it bears more thought. Especially so 5 or 6 of the suits have been brought by for-profit businesses, and what has struck me in the free exercise claims especially, and I think it would apply to RFRA as well, is the position that the Obama administration has taken. Because in their briefing in those cases, this is a quote, they said, "A for-profit secular employer by definition does not practice religion." And that's not obvious to me. That's not obvious to me, because we know that a corporation can have a free exercise claim. A religious corporation, a church, they can certainly have a free exercise claim. So does that change when you take on for-profit status? And then we mentioned before the Hercules Court's opinion, where they framed the question, but then they punted on it. But even the way they framed the question is interesting. So here's what the court said. They said, should a closely held corporation owned and operated by a small group of individuals professing adherence to uniform religious beliefs be treated differently than a publicly held corporation owned and operated by a group of stakeholders with diverse religious beliefs? Even that question, so the implication is, well, if it's a closely held corporation, then maybe, but we all know a publicly traded corporation could never bring a claim like this. And I'm not sure why that's the case either. I mean, in many areas, we empower management to speak on behalf of shareholders, even in ways that bind the company. Or if you compare it to a case like Dale versus Boy Scouts, where we said, we're going to defer to what the head of the Boy Scouts of America says their beliefs and their identity is, even if local constituents groups vehemently oppose that. So, it's not obvious really why we would say the ownership management split precludes a religious liberty claim. Then the second question the court asked, is it possible to pierce the veil and disregard the corporate form in this context? The implication of that is, in order to get to their religious liberty claim, you have to go through the corporate form to the individuals. Why would that be so? I mean, do we not have religious liberty claims that accrues to the corporation, to the association of individuals themselves? It's all made more interesting, of course, because of the Citizens United ruling. Right? Because Citizens United, the court says, you know what, we're talking about political free speech. The identity or the status of the speaker is constitutionally irrelevant. So when we get to religious liberty claims, free exercise claims, is the identity or corporate status or form of the speaker relevant now? I mean, we haven't had courts really grapple with this directly. Judge Noonan, in a dissent years ago, said, of course it's not relevant. Of course any organizational form can bring a claim like this.
So let me press you a little bit on the subsidiary arguments that DOJ is making, in addition to the one that Rob just mentioned. I think what's at the heart of DOJ's argument, I don't know that that was the best way to put the argument that corporations can't practice religion, is, as we mentioned, both sides of the RFRA equation. So on the one hand, it offers another way for the person with the religious beliefs, another option for them. They don't have to run the air conditioning company, right? They can do a lot of other things. They don't have to run a corporation at all. They have an option in a way that a religious organization does not, without really totally implicating its religious mission. And you saw this a lot. I'm not necessarily promoting this idea, but certainly the case law, there's these 9th Circuit cases involving the Fair Housing Act and prohibitions in the law against, you can't discriminate against non-married or lesbian and gay couples in housing, landlords. And landlords who only owned a few properties would come in and say, I'm against cohabitation. It's my religious beliefs. And one response of the courts was, that's fine, and we sincerely believe you that that's your belief, but you have an option. You don't have to be a landlord, right? So the law isn't imposing a substantial burden on you because you have this out. So that on the one side. And on the other side, of course, is what the other panelists have brought out, which is when you go into the for-profit world, however the exemption should be framed in the nonprofit world, once we cross that barrier into the for-profit world, doesn't the government's interest become dramatically higher because of the risk of many, many more religious objectors and really affecting the marketplace for employees?
Yeah, I think you're right on that last point. And so I think where I would come down on this is for-profit businesses should have standing to raise free exercise claims or anything, but we might need to be moving more toward what Fred Schauer and Paul Horowitz and others have been looking about, this institutional First Amendment, that there are certain core institutions that are important to the infrastructure of free speech or free exercise that get a heightened standard of protection that for-profit businesses would not enjoy. But your first question, though, I will push back on the first question. And that is, well, you know, they don't have to operate the HVAC business, or they don't have to, because you could expand that to such a range of activities. You don't have to be a pharmacist if you're pro-life, right? I mean, you don't have to sell those chicken sandwiches if you're going to, you know, take positions against freedom to marry for gays. But
isn't that in some sense true? I mean, Louise made the point. If you choose to enter into the commercial sphere to make money, you know right away on day one that that brings with it thousands of regulations that you have to abide by.
Well,
you
do, but see, here again, we're getting to some contested religious premises, but it's more implicit in your question, because there is some very, I'm just speaking from the Catholic tradition, there's some very rich theological work on the notion of vocation. Right? So the notion that, well, when you're doing your religious stuff, we understand that's an obligation and a commitment, but now you're just doing something optional. You're going out into the for-profit world, that's just something optional. There is still a lot of theological weight to that. Now, where I would agree with you is, and this is a judgment call, you can't completely redefine the nature of the professional role you've undertaken. So if I was say that if I'm somebody who's strongly opposed to the death penalty, and then I apply for the job as the state executioner, and I say, yes, I am entitled to the job as the state executioner, but I will not participate in the death penalty. Well, of course, that's ridiculous. That's the nature of the job. But a lot of these, so if you're a pharmacist, and when you got your pharmacist license, and then they've introduced Ella and all these other drugs, you know, it's not a case of, well, you should have expected that you were going to be regulated for all these things when you decided to become a pharmacist. You have no grounds to object. There's going to be degrees of difference in here, but the notion that, you know, the nonprofit religious world, that's central to the religious believer's identity and freedom of religion. But then if they open a business that has any dimension of financial profit, that's just something they can put on like a hat and take off without any cost to their own sense of who they are and their religious identity. I would reject that sharp distinction.
Okay, I want to save 15 or 20 minutes for questions from the audience. But before I do, let me ask a little bit looking forward. And I'll ask Lori and Melissa two questions, and maybe if we can have sort of quick answers, and then maybe they'll be fleshed out more in the Q&A. So Lori, you mentioned that the theory on burden, substantial burden, for at least some of your clients, and the difference between this and their payment of salaries or taxes is that it's a much closer relationship when they are the ones offering the insurance plan and maybe co-paying for it, for the premiums anyway. It's one step closer, right? And therefore, it's more of a proximate cooperation with evil, or so think these plaintiffs. But there seems to be some resistance, and I don't want to attribute it to Beckett, let alone all of your clients, but certainly within many different religious communities, there's been resistance even to this new accommodation that HHS promises, which is, okay, you won't have to pay at all. We're going to have someone who doesn't have a religious objection be the one that's offering it. Would that, I don't want you to speak for your clients and make a representation, but as someone who's thinking about these things, do you think that will take care of many of the religious claimants, even if not all of them, because it will break that chain or expand it further?
I think that it's not going to take care of my clients in particular. Now, obviously, I say that having not seen the final rule. We don't know what the final rule is going to say. You know, there are some people who are going to be satisfied. This is an accommodation. I think Melissa had said something about that in some earlier writings, that there were people who were satisfied with this. You know, when you're looking at the accommodation, there are several different groups of people. There are people who would be covered by it, but who have objections to still having to provide authorizations to the insurance company, who seriously have deep concerns that the money that they are paying the insurance company is still going to be used to fund these things. And so they have continuing objections. There are also, I have several clients who are self-insured, and so they are actually the payers. And so you get into these very complex questions about, can the third-party administrator pay it? Do they have enough money? Do they have control over the funds? And so there's a real problem with the compromise, at least especially as it applies to self-insured entities. And then you have the for-profits who aren't going to be subject to this at all. And so they are still going to be put in the position of, you must include this in your insurance materials, you must still pay for it.
And Melissa, I know you've been doing a lot of thinking about two related questions, which is one, what are these steps that have been floated by HHS, are they going to do the trick? Are those the appropriate ways to deal with this question? And two, if not, should HHS be thinking about more fundamental changes in this nature of its, not as a matter of law, but as a matter of good government in the scope, in the definition of employers who should not be subject to this requirement?
Yeah, well, I think that, as I think Lori suggested, I objected to the initial Obama plan and welcomed the president setting out new goals, two goals that I think both are very important. And one is that religious institutions that object to this coverage shouldn't have to pay for or provide the coverage, and that women working for objecting employers should have alternate means of accessing that coverage that don't involve the religious institution. In terms of the insurance companies providing it, you know, that seems, and third-party administrators, those make sense to me. They've made sense to some other religious groups. Not all religious groups are happy with that, and that's why Lori is bringing some of her lawsuits. I think that the administration, as it did, I think, with the advance notice of proposed rulemaking, should try to see what other ways might satisfy these groups of people who were not satisfied by the idea of insurance companies providing the benefit, even if it's not something they're legally required to do, but just because it's, I believe, the right thing for the government to do, to try to accommodate free exercise objections whenever it can do so, while also being mindful of the burdens that those accommodations might put on the women, in this case, working for objecting employers. So I hope that, and another reason that the government should do that is because courts can differ on their conclusions in these matters, and also because, as was discussed earlier, there's a grandfathering plan where many plans will not provide this contraception coverage. So I think it's appropriate for the government to take the posture of being very flexible with those who have conscientious objections and saying, can the government, for example, itself provide these benefits through the insurance exchanges? And might that be a way for us to make some movement forward? I hope the government will fully explore all those options. Obviously, the parties aren't going to agree about everything here, but I think we could make some progress, and I hope we do so through the rulemaking. Let me just also say about the exemption. I'll try to keep it very quick.
The first exemption, you mean?
The first exemption, yeah, that has the 4 prongs that we talked about. I've said from the beginning that I have problems with that exemption. I agree with some of Rob's critique of that exemption. In February, when the president made his announcement and the final rule was issued, I think that the accommodation can be a workable solution if they're careful. If they do hang on to that 4-part exemption, there can be a workable solution if the accommodation is made very essentially the same as the exemption, where the provider doesn't have to pay for, the religious employer doesn't have to pay for or provide the benefits. But I still think the best course is for them to revise that 4-part exemption. And they could do so in a variety of ways. I'm happy to talk about how to do that if there's a little bit more time to do so. But I do think the exemption itself is faulty and should not be extended in federal law, certainly.
Okay, so we have at least 12 minutes or so for Q's and A's, and I want to see first if any of our fellow participants have questions that they don't think they'll be able to address on their own panels. Kathy, go ahead. You can introduce yourself, since everyone will know you a half hour from now anyway.
Okay. Kathy Caveney, Notre Dame. This is just, it's a legal informational question, not an argumentative question. What do you, for distinguished lawyers on this matter, think about whether or not RFRA is actually going beyond, in terms of the protections offered to religious institutions, the standard that was in place the day before Smith, was decided? Has RFRA not just restored the pre-Smith standard, but actually extended new protections to religious institutions? Because sometimes when I look at the literature, it seems to me some people are claiming it's actually giving a new set of protections, at least in the case law, and not simply turning back the clock to the day before Smith.
I mean, I can start by saying I think the legislative history is clear that Congress wanted to incorporate the entire corpus of pre-Smith law, hook, line, and sinker, and continue along the road the court had been pushing and pulling on for those 25 years. But do any of you have views on whether, in fact, the adjudications under RFRA have differed significantly from the free exercise jurisprudence that preceded Smith?
I think there's one piece in which the narrative about Smith makes the pre-Smith life sound a little bit tidier than it was, but I wouldn't go from that to saying that the RFRA life is radically different. But
right. I mean, for what it's worth, the government is citing almost exclusively pre-RFRA free exercise decisions like the Lee case. This is a case in which the court held that certain employers who had religious objections to paying into the Social Security system should not get an exemption, in large measure because of a compelling government interest in not opening up that door for who knows how many employers. That's the government's lead argument in these cases. So the government surely is making use of the pre-RFRA cases.
Everybody is, yeah.
I'm not aware of any great deviation on the part of the courts from RFRA. Are you here, Bob, somewhere? Bob Tuttle? Hi. Are you aware of any deviation from the Smith? That RFRA is going in a different direction than the court went under the free exercise clause. I don't. Right, and that's what. And one thing I wanted to mention in response to Lori says, and you're right, Lori, it's not that RFRA is new. It's been on the books since 1993. Another indication of how old we are. But there isn't a lot of law. And another point the government tries to stress in these briefs is it's not as though there's a bunch of case law saying that employers in particular are entitled to RFRA exemptions from a whole spate of employment laws that are out there. Now, it's not like there's a lot of cases rejecting such claims either. There just haven't been very many such claims. The government cites a handful, but that's all I'm familiar with, really.
I would just add, though, if I was a litigant challenging a federal statute, I would much rather be able to look to this RFRA language than to have to look to decades of case law that emerged that were fact-driven in many ways. It's just, you're right. It's much tighter when you have the standard laid out by Congress and you can just sort of wield that as you need.
I would agree with that, but I would also put in a plug for overturning Smith myself. It's something that I would much prefer to have a revisiting and a revising of the Smith decision as well as the federal statutory protection.
So that would basically mean if the court were to reverse Smith, it would apply the RFRA standard to state and local laws as well as it purported to do for 25 years for a quarter of a century between 1964 and 2000. Anyone on this side with a question? The woman at the top. Is he going to ask the question?
No, it'll be me. He might have some comments. Wow. My name is Dr. Marguerite Duane. I've been with the Georgetown School of Medicine since 2004 and medical director of Catholic Community Health Center for the last 4 years. And I'm speaking on behalf of myself as a woman, a physician, and a person of faith. And I want to address the 2 points I believe Louise Melling made regarding the main issues of this being discriminatory against women and what's in the best interests of the state. And the argument that if women do not have access to contraception, that this is going to discriminate them. It will be more of a financial burden and will create a lower economic return in the workplace. And I would raise the question, what about the discrimination against women of faith? Because one thing that the mandate does not cover, it covers FDA-approved forms of contraception. It does not cover counseling or training or education in evidence-based methods of natural family planning, even those developed by Georgetown's Institute for Reproductive Health. So if a woman wants to go and learn how to truly understand her fertility so she can monitor it and make informed choices regarding her family planning, she cannot get that service covered. So a woman of faith or a couple of faith who are interested in that would actually have to still pay out of pocket for that. They would not have they would have the option of using methods that they're opposed to as opposed to those that are consistent with their faith. And when we look at the best interests of the state, these are extremely cost-effective methods. I mean, personally, in the last 8 years, I've spent $30 on a textbook and some additional training, and that's it. And my insurance didn't cover any of that or pay for any other family planning options. And I was able to use that information to effectively plan for my family in an effective way without creating a diseased state or suppressing fertility. So I would like the panel to address the discrimination against women in that regard and the fact that this mandate does not cover those methods that have been well researched and studied and proven to be effective.
I have to say I don't know the answer to this. I know that the preventive care covers some counseling, reproductive rights counseling.
And the counseling doesn't cover.
But it doesn't cover. Sarah? Do you know if any comments were raised? I suppose it might have to be with FDA because HRSA has sort of incorporated by reference forms of contraception that FDA has approved. This isn't quite that. Did anyone make comments suggesting that to HRSA? You did. And did they mention it?
I don't know why that is.
I wonder would anybody have an objection to it because
I wouldn't think so.
You know, I would
no, I wouldn't think so at all.
It would be pretty consensus. It'd be a consensus item.
Yeah, exactly.
Right, but certain forms of counseling, not drugs or services, but counseling is covered under the HRSA rule. I just don't know the full scope of what that counseling is.
I assume it is because the same way condoms aren't covered, right? In the sense it's not a prescription, right?
Yeah, if someone in the room knows that how HRSA has treated this.
I don't know why that happened, and I would agree with Melissa. I can't imagine the person having the objection to having coverage for that counseling at all in service.
Is there a quick answer to this question? Okay, well, you're on that side of the room, so you're the lucky winner anyway.
So my name is Sally Steenland, and I work on the faith team with the Center for American Progress. And I think we need to be careful when we blanketly say women of faith, because most women of faith, from a variety of faith traditions in this country, it is their religious liberty and their conscience to support contraception and to support family planning, not just for their health, but for their conscience and their religious liberty. Their faith traditions support it, and their health supports it as well. So I think we need to be careful and not just make those blanket statements.
Okay, anyone else on this side of the room? Yes.
Marty, I'm just going to pick up on this a second.
While I'm running.
While you're traveling. And just to pick up on I'm Amy Ullman here at Georgetown as well. Just to pick up on the discussion between Rob and Louise about a purpose versus the purpose and the problem of notice, and I think it's actually related to both of these points. That if you can comment on what is the point of reference from which we think about the question of notice, because there was a very deep kind of cultural fissure in terms of how we're understanding the place of religion in society and how religion interacts with culture. And so I guess the question is, notice in what context? And if you're walking into, for example, a Catholic institution, is it notice for the theological framework that Rob was laying out? And if you're walking into a Lutheran institution, how is that different? So just to kind of open out the cultural implications of how we figure out who's on notice when and why.
I was using notice and also using core religion. I take your point seriously in the sense of not meaning to say that a person who is, that being a pastor is a different moment of faith necessarily than being running a charity, that those are all very sincere, heartfelt, critical ways of expressing faith and driven by faith. I meant it, I think, much more in a sort of secular kind of way, so forgive my... For when I think about notice, I think about the ways in which if you work for a church or a temple, you sort of understand what you've kind of walked into, especially because it is, and here I'll correct myself, the primary purpose is around faith, and you have a reasonable expectation of a different set of norms, that you may be outside a whole host of federal regulations, and that we have carved out places of faith in many, many different respects for different rules and held that sacrosanct in a different way. Whereas when you take a job at the Catholic hospital, which is now, one in 5 beds approximately in America are in Catholic hospitals. They're very, very large institutions, very, very large employers, that many people are sort of taking a job and not expecting when they take a job in many different ways to then be sort of embracing and subject to a set of norms that are about the Catholic faith as distinct from hospitals and public employers. And then when you go even further out to some of the private businesses, and I realize some of the private businesses have, it sounds from reading your briefs, a whole many different religious indicia, but you go in there also expecting a different set of rules. And if you have religious employers asking their employees, requesting exemptions from the whole host of traditional public rules that govern businesses and other public institutions, then you really are imposing your faith on those people. That's really how we look at it. And whether that is in your salaries, whether you don't pay people the same, you pay women differently, or you have different rules. And so it's notice kind of what you're getting into. I don't mean it in a technical sense, it's sort of an equity sense.
Yeah, I was just wondering if you could speak to sort of the facts as they came out with respect to Wheaton College and sort of the controversy over Wheaton College having filed one of these lawsuits and then information coming out that their health plans had provided coverage for emergency contraception or other forms of contraception. And I know people on the panel have said that they're not questioning the sincerity of religious belief, but sort of to an outsider, that's a moment where I question the sincerity, or the objection looks a little more opportunistic than more long-standing policies.
Yes, it is. Yeah, and that is what we're getting to, is the sincerity of it. Wheaton's teachings and its beliefs about this are long-standing. They are sincere. What happened in that case is you had an organization who, they do not have objections to all forms of contraception. They do have objections to emergency contraceptives, Ella and Plan B, because they can believe it could terminate a pregnancy in the very early stages, which goes against their beliefs and teachings about when life begins. In their case, they discovered that they had provided inadvertent coverage, and this was something that they were surprised and disturbed to learn, and as soon as they learned it, they turned around and started working on getting out of their policies, and it is now out of their policies. And so while I understand that people are concerned when they hear this, I think it is important to realize that these teachings and beliefs of these organizations have been consistent, and that our religious freedom should not be dependent on whether or not we've ever made some sort of bureaucratic error.
Sorry.
Go ahead. I'll get another question.
We have 2 more minutes, so maybe I'll take 2 questions, 2 or 3 at most, and then have the panel have quick responses. So please be very quick. Thank you.
Okay. My name is Scott Maccabee. I'm a student in Brooklyn Law School, and I work on the Hill this semester. So one topic that has come up on the Hill in our conversations about RFRA and the legislative history when RFRA was passed is the tension between the freedom of religion versus the Establishment Clause, and how do we as lawyers moving forward breathe life into the Establishment Clause, because it may seem that the Supreme Court has run roughshod on the Establishment Clause in the name of freedom of religion. And the simple answer would be to change the members on the court. But there may be other answers as far as legal strategy. So I was wondering if anyone had insight into
Let me
that.
answer that quickly. This could be the subject of a whole nother symposium. But there is a whole nother set of doctrine in the court about when permissive accommodations, exemptions for religion, go too far and violate the Establishment Clause. RFRA was drafted with an eye toward that, and in theory anyway, the terms of RFRA satisfy the test the court has developed so as not to violate the Establishment Clause. Obviously, at the margins, there are very difficult cases, but I think those of us involved in drafting the statutes, at least on their face, were with an eye toward the court's jurisprudence. And in particular, the court has been concerned if a religious exemption imposes a substantial burden on third parties. That may raise deep constitutional questions under the Establishment Clause, and the theory that some private party should not have to pay for the religious exercise of others. That's obviously a theme raised by all of this, to the extent one thinks that women and female employees are bearing the cost of even the exemption that the HHS has already crafted. I'm skeptical, however, that the Supreme Court, especially this court, would hold that it violates the Establishment Clause. But in any event, we've tried to be sensitive to that. I think everyone has in crafting RFRA and similar statutes. On this side, yes.
Thank you. Hi there. I'm Alex. I'm a JD MPH student from Northeastern and Tufts. I want to look at one point that Ms. Wyndham mentioned about the Hercules Inc. case, which was that, and again, just recently, that emergency contraception was being conflated with an abortion drug. And if I understand correctly, the contraceptive benefit doesn't require any abortion drugs to be covered. I guess my question is, can someone have a valid RFRA claim under a perceived imposition that doesn't quite exist because the emergency contraception isn't an abortion drug?
So this gets down to not a theological dispute, but, well, it's partly a theological dispute, I suppose, but about what if an employer disagrees with HHS? HHS thinks that their approved methods of contraceptions are not abortifacients. If they were, they couldn't be covered. There may be an employer out there who thinks, we respectfully disagree, and that disagreement could be based on theological differences about what constitutes an abortion and when does the zygote become a life and these sorts of questions, or it might be based on a scientific, a factual dispute about how the contraception actually works. And it's an interesting variant on the question we've been asking. Should the courts, if it is more on the factual scientific dispute, should the courts take at face value the factual predicate of the religious objector if HHS has concluded that that factual predicate is simply mistaken? I don't want to get deeply into that here, but I do suspect that the litigation will touch on those issues. Do folks agree?
Yes. Right?
Yeah, but I think that we come back to an idea that we were talking about earlier about the Thomas case, where it talks about religious, when we're talking about free exercise matters and what people believe as a religious matter, they don't have to prove that that is right to the court. And it'd be a problem for a court to get in there and try to manage that inquiry. Of course, when the government itself is making decisions about whether something is an abortion-inducing drug or not, then it's a different kind of analysis we're doing, and we're going on the science that is available and making the best scientific judgments. So I think about it those two different ways.
One more, yes, ma'am. One more.
Hi, I'm Destiny Decker with Traditional Values Coalition, and I had kind of maybe just a thought. I don't know that it's a question. But several panelists had mentioned the point of access and discrimination against women because the lack of access to contraceptives, and I don't think that many people in this room would argue that access was the problem. I think it's more of having to actually pay for contraception. And there's plenty of research showing that the higher level of education you have, the better off you'll be, the more healthy you'll be, less children you'll have, that kind of thing for women. But I don't see anyone making the argument that the government should pay for everyone's education. We all have access to it, but it's not discrimination when one person has to pay more because they've decided they want a better education or they want, better access to a different type of education. So I don't know that access to contraception really comes into play. It's more of they should have it for free. I don't know if that adds anything, but I don't think that's a good argument to say that access to contraception was one of the main reasons, kind of like if it's not broke, don't fix it.
I think that's a policy dispute, a very significant one, but one that HHS and HRSA and the Institute of Medicine disagreed with, both on health grounds and, as I was suggesting, on equality grounds, because it results in women having to use many more of their salary dollars to pay for health care than men do. Those are obviously questions that are subject to debate, and we're subject to debate and continue to be subject to debate, but I don't think the courts will start second-guessing Congress's judgments in that respect, and HHS's
isn't the government also saying that here we want to, we believe it serves a government end, many government ends, not just access, but to provide this without cost sharing because it'll drive down unintended pregnancies, for example, and poor health outcomes for children and mothers. And, from my point of view, I hope that it reduces the number of abortions that happens. And that's something
it's interesting that that's sort of been lurking but not stated anywhere in the briefs of the rules. That obviously one of the great healthcare and cost questions is not just an unintended pregnancy that goes to birth, but that the incidence of abortions will increase.
Right, and I think that a lot of the forms of contraception that are the most reliable are also the most expensive and require doctor's care and prescriptions and regular checkups and all the like. So I think the government was saying for a variety of reasons, let's do this as a public health goal. It serves many different interests, and we want to further that interest. And I think that's a perfectly legitimate thing for the government to do, and I hope it does have many of these intended effects. At the same time, I think it, shouldn't enlist objecting religious institutions in being a part of that. So I think we're trying, at least from my point of view, to pursue both goals at the same time.
Please join me in thanking what I think is a really extraordinary and seldom to be repeated, wonderful panel of folks who have provided such interesting and expert analysis of what is sure to be a continuing issue in the months and years to come. Thank you very much.
Thanks, Marty.